to start this morning with looking at hybrid working. Now, one of the lasting legacies of the pandemic is, of course, the changing landscape in relation to flexible working. And the government has recently announced that it plans to commence a consultation over the summer to seek views on whether flexible working from home should in fact become the default option unless there are good reasons not to. Contrast that, of course, with the current statutory regime where a formal request comes in from an employee with 26 weeks service and it can be confirmed or rejected for a number of business reasons after a prescribed process has been followed. Now, what we found is that most of our clients across a variety of sectors, in fact, are leaning towards a hybrid working policies with perhaps a minimum number of days in the office each week, but with some flexibility over the particular days. Now, the working arrangements that will best suit your business, of course, will depend on lots of different factors. It might vary from employee to employee depending on their seniority, the level of supervision required, perhaps whether you're in a regulated sector, whether you can ensure that you have good business continuity with home workers, and any knock-on effect on client service. I think one of the messages also that comes across very strongly from our clients is that many are concerned to preserve their positive culture. What you're going to need to consider are the employee relations issues in terms of implementing any working arrangements. A key consideration in that is whether to adopt a more principle-based agile working policy rather than setting down a prescriptive set of working rules for employees. I think there are benefits and drawbacks to both approaches. Principles obviously offer quite a lot of flexibility. So as your new policies bed down over the remainder of this year and into next, they can be adapted to cover perhaps unforeseen issues that may arise. For example, a drop in productivity. And further detail can be added to the rules over time. Many employees will likely appreciate the ability to control their working weeks while also working, of course, within the parameters of business expectations. But in contrast to that, prescriptive rules may be harder to adapt and perhaps give employees scope to argue that the rules create actual or implied contractual rights. But the rules offer business certainty and also certainty to employees and perhaps enhanced accountability. And some businesses, I think, may consider that that's a trade-off that is worth making. Our general recommendation is caution in relation to implementing hard and fast rules which can't be changed, because flexibility, I think, is really key here, because it is difficult to foresee how effectively new working arrangements will be in practice and the challenges that they will throw up. Agile working principles, which are regularly reviewed and updated, I think offer more scope to change than fixed rules. Could I have the next slide, please, Jess? So how do you minimise the risk and maximise the reward from a hybrid working model? Well, it'll be really important to keep a close eye on any undesirable consequences of hybrid working, such as the risk of a two-tier workforce or perhaps particular groups of employees who are disadvantaged, such as female workers, and potentially exposing the bank to indirect discrimination claims. And impact assessments will play an important role in assessing your chosen agile working policy and how effectively it will be in practice. So these should really be carried out regularly. Do make sure that your workforce understands the rationale behind your new working arrangements before these are implemented, ideally. Factors such as team collaboration, risk management, supervision and monitoring, and any regulatory requirements are all relevant considerations that can be documented and fully explained to staff to justify your decisions. Where possible, it's helpful to consult employees, again, before proposals are finalised, and build then any appropriate general suggestions or feedback into the new arrangements. Individual employee concerns, though, should be dealt with on a personal level, and obviously grievances should be addressed through the normal channels using your internal grievance policies. I think one of the key things is that managers should be trained on any new policies and protocols, and that's because you want to ensure not just that they understand what they are and can implement best practice, but also that they do so consistently across the business. Because being inconsistent brings with it the risk of claims for differential treatment. And of course, that could include discrimination or constructive dismissal claims, or just poor employee relations more generally. Could I have a next slide, please, Jess? So I just want to touch on a couple of tricky issues that you may face with the sort of change to your working model. And the first of those is reluctant returners. Now, there may, of course, be a variety of reasons why some employees are reluctant to return to the office or to commit to a new hybrid working arrangement. And we generally recommend a cautious approach with reluctant returners. It may be that their contract can require them to work in the office, and it could be considered a reasonable instruction to ask them to do that. But the impact of COVID on their personal circumstances, I think, should not be underestimated. And we think that tribunals generally are likely to adopt a fairly sympathetic approach for some time to come. Although it's not a given, of course, that COVID-related claims will be successful, particularly if you followed all of the appropriate health and safety requirements and your workplace is kind of COVID secure for the return to the office. An example of one of the cases that's coming through now from the employment tribunals is the case of Akitatis and Fortuna Group. And in that case, the employee, who was a sales and project marketing coordinator for a firm that distributed PPE, failed in his claim for automatic unfair dismissal in circumstances where the employer had required him to attend the workplace rather than agreeing to his repeated request to be placed on furlough. Now, the employment tribunal accepted that the COVID threat gave rise to circumstances of danger, which the employee reasonably believed to be serious and indeed imminent, but it held that his demand to be furloughed wasn't an appropriate step to protect him from danger. It said that it was clear the company had never been busier, they had taken steps to make the workplace COVID secure, and the individual's job could not be done from home. Now, this is obviously a helpful first instance decision, but it's always worth keeping in mind, of course, that these cases are inherently fact specific, and in different tribunals, different views may be taken. Could I have the, oh, sorry, not the next slide yet. So the next point is always to consult with your reluctant returners directly to understand their concerns, and also work out if steps can be taken to alleviate those concerns. It may well be that there's relatively small adjustments, such as allowing them to work in less busy areas of the office, or perhaps adjusting working hours to prevent travelling to work on the tube or in rush hour will be enough. Remember, of course, that with an employee who has a disability, you would, of course, need to consider document and implement reasonable adjustments in accordance with the requirements of the Equality Act. Now, as a very last resort, really once you've explored all options, it may be possible to require a reluctant returner to revert to office working, and you could use the disciplinary procedures if necessary. But if that does become relevant, there are likely to be risks around constructive unfair dismissal or health and safety detriment claims, and possibly discrimination issues to consider. So it's always advisable to take some advice about the most appropriate course for your business, balancing the desired outcomes with the risks. I could have the next slide, please, Jess. So the other issue, tricky issue I want to touch on is updating your employment contracts. Now, if you're planning to tailor employment contracts to cover new working arrangements, obviously the first step is to identify which clauses are affected and which variations are required to meet your future needs. If you have an existing mobility clause which permits flexibility over the location of the workplace, then it may well be that wholesale changes aren't actually necessary to implement a new agile working policy. But remember, of course, that amendments to employment contracts should still be implemented with specific employee consent where possible. And the best way to achieve that is by providing sufficient information about the proposed amendments to allow consultation with employees in relation to the impact on them and on the business as a whole. Now, the other advantage, I think, of the consultation process is that it does help you to identify any resistors and also to explore the risks, such as breach of contract claims, discrimination, constructive unfair dismissal, that are associated with unilaterally imposing any changes. Now, as a very last resort, you may consider dismissal and re-engagement if consent is not forthcoming. Now, it may be that you only use the contractual ability sparingly, and once you've considered all of the risks in relation to the individual, but we think it remains good advice to have a contractual power to require an employee to attend the office if you do update contracts to provide for employee flexibility. Now, one thing you do need to bear in mind is the potential to engage collective consultation obligations under the Trade Union and Labour Relations Act of 1992. I've summarised those on the slide, but broadly, these may be triggered if there's a proposal to dismiss employees on their current contracts and then to offer them re-engagement on your new updated contracts. And there are at least 20 of those employees at one establishment. and that process takes place within 90 days. And that's the case even if no redundancies are contemplated, because the definition of redundancy for these purposes is a dismissal not related to the individual concerned. Now, as you'll be aware, information and consultation timetable is prescriptive, and you face a potential hefty tribunal award for any breach. That's 90 days pay for each affected employee that you haven't informed and consulted. You've also got to submit a form HR1, and if you don't do that, there is a criminal sanction attached for a failure to do so. So if you do foresee that you might need to dismiss and re-engage people on new contracts, if they don't agree to sign them, then we'd be very happy to assist to ensure that you stay on the right side of your legal obligations.